Hello, everybody. Racheli here with Fairway Mortgage, and I have Courtney Kahn. She is the legal counsel for the Our World, which is the real estate board for the Broward and Palm Beaches. So, Courtney, thank you very much for joining us. And we're going to be talking about some NAR things.
Hello, thank you so much for having me. I'm so excited to be here today and to be here. As you stated, I'm with Broward Palm Beaches and St. Lucie Realtors, and we have a lot going on with these lawsuits and the proposed settlements and all that. So I'm excited to get into that today.
Love it. And I would like you to share with us what are the news that you have seen or changes that you've seen since it broke up. And we did an interview with Chris, who is the past president, and quite a few things that we discussed then are no longer the case, or there are new things that we need to discuss with them. So give us a few.
I'll start off by saying it's certainly never a dull moment in our world, especially lately. And so even since I know Chris was on this podcast, even since he came on here, tons of changes have happened already. So I do want to get into some of those. And, I would say probably the biggest item that we've seen in the news already was the motion for preliminary approval, which was filed and granted. I'll take a step back for a second. It's typical in a lot of class action cases to require court approval before any settlements can go through. So that's what's happening here. NAR has a proposed settlement, but it needs approval from the court before it can be final. And what that approval looks like here is really a two-step process. So you have to get preliminary approval and then final approval. So the big news aspect was that we have received that first step completed. We've received preliminary approval. That was granted on April 23rd. So pretty recently. Now we are just waiting for final approval, and we do have a date on that final approval. We now know that the final approval hearing will be November 26th. So November.
Oh, so they're pushing it.
Yeah, so November 26th will be the final hearing, although I will mention that the practice changes that NAR is going to put into effect are actually still going into effect before that final hearing. So I know sometimes that kind of confuses people because you think, usually changes would go into effect after something is final, but in this case, the NAR changes are going to go into effect before that final settlement approval. And so those changes are expected to go into effect on August 17th now, which is also a pretty big change because I know you've probably seen in the news before a lot were saying that they expected the NAR changes to happen in mid-July at first, and then we had kind of heard end of July. So, now they're saying August 17th. So it is going to be.
We're going to start implementing things even before the final approval.
Yes. Yeah.
Okay.
Yes,
okay.
We will start those changes before we get that final approval.
So now that we know it's going to go into effect before, what are some activities and behaviors that real estate agent should not do, should not be engaged in? And so just to be on the right side of the law and not get in trouble.
Yeah, I love this question because there's a lot of list, as we've seen throughout these lawsuits, of things not to do and things to do. But I definitely want to, mention some things not to do that we've seen highlighted throughout all of these lawsuits going on. The first I would say is that saying that there's a set commission rate is definitely a big not to do. That was brought up, throughout all of these lawsuits. I would say kind of the magic words are that commission is always negotiable and it's not set by law. And, we're seeing the courts bring that up, and we're seeing in the proposed NAR settlement that language is going to be required in all the contracts going forward. So making sure that you really understand that commission is always negotiable, it's not set by law, and that you implement that in all of your business practices as well.
So let me ask you about the commission. I know that I'm not a realtor, but the real estate agents should not put it will not go anywhere on the MLS.
Yes.
However, can you put it on the contract? Can you put it on your website? Can you put a post on social media?
Yes, so that's a great question. As a result of this settlement, what they're implementing will be that the offer of compensation will be removed from the MLS, so it will not be anywhere in the MLS at all, but you can still do offers of compensation, and so that will still be available. And so, as you mentioned, you can place that in an offer for a contract. You can place it on your own websites. The caveat is it has to be for your own listings. So you have to make sure that if you're posting an offer of comp on your website, it's for your own listings only. You know, you can also call the listing agent, email them, text them to find out if they're making an offer and what that is. So there are various options for that you mentioned.
One question I'm going to ask you, this question came up at the Marketing Madness, that if you have the feed on your website that comes from the MLS, you cannot mention those commissions on it. Do you know anything about that?
Yeah, so that's a great question. There's still several aspects that we're looking into here. So that's one of them that we're going to get some more clarity on before we implement all of our rules. But I will say generally, anything that's tied to the MLS will also not display offers of compensation. So things like showing platforms, even our broker remarks sections, really anything that's related to we're getting a feed from the MLS also cannot display all of those different offers of compensation.
Okay. What are some questions that you seem to have, like in the last 30 days, that keep agents calling you or calling the board or calling and keep asking? And you seem like this question is like we've been chewing it.
Yeah.
What would be like a couple of those?
So many questions. We've been getting so many questions, but definitely there's a couple that I would love to highlight. And, you know, I think knowledge is power. And so as this goes further along, we're getting more and more insight and clarity on the settlement. So it's definitely, we're at a point now where we've gotten several more answers than we had when we started. So that's good. But there's two in particular. We've been getting a lot of questions regarding how to handle current agreements that licensees have, because a lot of the changes in the settlement, for example, as we mentioned, it requires offers of compensation to be removed from the MLS, and it requires agreements to have that magic language I mentioned about commissions being always negotiable and not set by law. And so the questions we're getting are, how do we handle this with current agreements? Do we have to modify those agreements? You know, what do we have to do with the ones that were already signed, but then these changes go into effect? Do those have to change as well? And so we did receive some clarity from NAR regarding that aspect. I will say too, a lot of the clarity and updates that they're providing is on their website. So that's a great place for people to go and check that out. NAR has an updated FAQ section. It's on nar.realtor/thefacts. And they have a lot of these answers there. But what they have told us is that as far as the compensation is always negotiable and not set by law disclosure, they did say that MLS participants will have to make that disclosure, but the active agreements do not need to be amended to accomplish this. The MLS participants can do a separate disclosure to satisfy the requirement. So they can do that disclosure separately in another document, but they don't necessarily have to change the actual underlying agreement. So I think that's a really good point as well.
Okay, that's a good one. Because people were like in the limbo, they were like in between the chairs. I did this, but I'm not supposed to do that as of this date, but I'm still in the contract with this one. So yeah, that's a good.
And then And then as far as the other component of that question, where the offers of compensation will be removed from the MLS, NAR did provide clarity on that as well. And what they stated was that if the agreement references that you have to make an offer of compensation through the MLS, you will have to amend your agreement to remove that, of course, since you won't be able to do that once the practice changes go into effect.
Okay, so how does, and this is a question again that came through the marketing madness that we have at the Real Estate Association, and I suggest realtors and affiliates, please join us over there. It's an amazing meeting. The question came up, a buyer agent comes in, and how do they ensure that if they cannot put it on the contract, how do they ensure that their brokerage and the agent will be paid?
Yeah, that's a great question as well. So there's a couple options that you can address in your agreement with buyers on that. You can, of course, get paid through your buyer. You can get paid through the seller. Offers of compensation would still be available. And of course, there's a bunch of different ways and methods that people can get paid. So there's tons of options for them. Really, all of those options are still available. The only big difference there is going to be that the offer of compensation can't be on the MLS. But other than that, the other negotiation tools and method for payments will still be there. So, you know, I always say a lot of these changes, they're important and they're a big deal, but at the same time, they're not, you know, it's not anything that I think people should really be freaking out or, you know, having huge anxiety over, because they're very doable. A lot of these changes, as long as you're educated on them, you know, it's very doable. It's nothing that we can't handle.
Yeah, it will take a little time to just get used to how things need to be.
Right.
And honestly, I love it because it's like shaking the tree and says, okay, here are the professionals. These are the people that will implement. These are the people that will do it the right way.
Yeah, you know, they always say that with change comes opportunity. So this is a good opportunity for people to fine tune their skills and, you know, make sure they're really educated and up to date on the laws and everything in our industry.
And another question that I would like to ask you, and how does the litigation between the Department of Justice and NAR affect NAR settlement and how NAR act on behalf of the real estate world out there? And how do you think, what would you think is the biggest impact it will have?
Yeah, this is actually another question that we've been getting from tons of our members as well. You know, everyone wants to know how that litigation is affecting all of these settlements. Of course, because we received that news not that long ago that when the Department of Justice appealed the decision with NAR, the appellate court actually indicated that they could keep investigating NAR. So a lot of people are wondering if that impacts the settlement and how it does. And I will say the short answer is that it does not affect the NAR proposed settlement at all, actually. What we've seen in the past in some cases and what we could see with NAR's proposed settlement is that the Department of Justice could certainly weigh into the case and they could provide their thoughts and opinions on the settlement, as they have in the past. However, it's important to note that the Department of Justice is actually not a party to all of those class action lawsuits and copycat lawsuits that we're seeing. So, for example, the Sitzer/Burnett case that went through a jury trial last October, where the NAR proposed settlement started. The Department of Justice was not a party in that case. They're not a named party in the case. So, you know, they could weigh in on the proposed settlement, but they're actually not a party to that case, which means that their litigation with NAR is totally separate from this other Sitzer litigation.
Okay.
Yeah.
So how does the Broward Palm Beach Port St. Lucie board is preparing agents? What do we do to just help them through the process of implementing those changes?
Yeah, so again, as I said, knowledge is power. And I think arming our members with tools, resources, and education is really the best way to go about it. And we have really been on top of that. We have tons of resources and tools available for our members. The first one I think is really critical, and I'd like to mention, is our settlement website that we created. We created a website that is strictly for resources regarding the NAR proposed settlement and all of the information with that. That website is actually ourworld.com/settlement. And so we've been posting tons of info on there. We have all of the links to NAR's resources on there. We have the full settlement there if anyone wants to read it. It's pretty lengthy. We have that there as well. We have a timeline on that website, which goes over all of those expected dates coming up that we mentioned early on. So that website is really critical. We also have a new email series that we started, and it's called Navigating the Settlements. And so that's really a weekly email that we've been sending out to our members that just talks about any new issues that are coming up with the settlements, or any other important information that people may have missed. So that's been a really good resource and tool as well for our members. We also do give access to our members to RIS Media, which is a really good resource. They've been providing a lot of updates throughout the cases and litigation going on and the settlements. And so they've been really good about staying up to date in the moment with all of these changes happening. So that's a really good resource as well. And then last but not least, we have been offering a lot of classes on using buyer agreements, since buyer agreements are going to be required as part of the NAR proposed settlement. We've made sure that we've been offering tons of classes for people on how to use those agreements. So we've been offering those in person and virtual, and we've been offering them pretty much on a weekly basis. So our members can sign up for those, how they sign up for all their other classes, but that's been, a major education tool as well.
Can you mention a couple things that you got from what they're teaching in those classes that the agreement, the buyer agreement has to have, or has to include, or has to cover? That
so one of the biggest ones, and I know we mentioned it before, but it's so important, I'm going to say it again, is that magic language that will have to be in that agreement, that commissions are always negotiable and they're not set by law. So that will have to be in that agreement, as well as listing agreements, on the other side. But that language is really critical. I'll also say, I think a pretty big takeaway when using those agreements is making sure that you're articulating your value. And I know that's been talked a lot about, throughout these proposed settlements and in our industry. But I think going forward, especially with using these agreements and getting them signed, it's going to be important to make sure that you know how to convey your value and what you're doing for your clients and customers, and making sure they understand, all of the steps that you take to get them to the closing table.
Right. A question that a realtor asked me: what if the buyer signed the agreement and it says buyer agrees to compensate the real estate agent, but then in turn they are going and seeing a home, they put an offer, and the seller is offering to compensate the agent? Do you need to change the agreement, or you just slide, and as long as it's on the contract and they pay? Can you do a combination between buyer paid buyer agent and seller paid portion of the buyer agent?
Yeah, so it'll be So it'll be up to everyone individually, really, how they want to handle compensation and where that's coming from. But a lot of the contracts will address that. I know Florida Realtors is anticipating updating their agreements as well. They do have buyer agreements already available, and they're anticipating updating those pretty soon. It's looking like the end of the month. But I know that their contract, for example, does address that already. And so they do have some provisions in there that talk about how to handle receiving compensation from the buyer. Or, for example, if it's coming from the seller, then, it is possible that the buyer wouldn't have to provide that compensation if the seller ends up paying that compensation. So that's definitely a possibility. There's tons of ways that people can go about that. What's important is that they make sure that they negotiate those amounts and that the people they're working with understand who's getting paid, how they're getting paid, where that money's coming from. It's really all about transparency. Transparency is key. And so as long as whoever you're working with understands that process and the compensation structure, that'll really help keep you out of harm's way.
Great. So if I can summarize this conversation, it's very I would say I feel more, I'm looking for the word, inspired that things will be better. People will be more professional. They'll bring their skills to the next level. Maybe they'll take some classes to be a better real estate agent.
Yes.
And the sky's not falling. It's just rearranging the cards on the table a little bit to make sure that it applies and everybody's happy.
Yes, I love that you said that. The sky is definitely not falling, There certainly will be changes, as we said, and it's always a challenge in the beginning to get used to changes, but they're very doable as long as everyone is staying educated and up to date. Then, again, the sky is not falling.
Right. And one thing that I may suggest, and this is something that came after the conversation with Chris, because we did not know what will happen if the buyer has to pay it or the seller is giving the compensation. How will it affect the ability and the numbers that we do for a buyer? It's going to stay the same as it is right now. It's a customary fee. It's not going to be added to what the maximum compensation a seller can pay, which is like 3% or 6% in different loans. So that will stay the same. So not to worry about that one. Fannie and Freddie clarified that.
Yes, yeah, we did receive that clarification from them. We haven't heard too much further from them regarding these proposed settlements, but I think what I've been kind of hearing through the grapevine is that they're also waiting to see how all of these changes play out. And after they go into effect, we can possibly expect more commentary or maybe changes from them. But as of right now, that's pretty much where we're at.
Yes, I'm sure that things will fall into the right places where they need. So, Courtney, I really, really thank you for coming in with us this morning, sharing your thoughts with the realtors that are referral partners that we work with. And hopefully people will feel a little bit more at ease.
Yes, I hope so. And thank you so much for having me.
Thank you.